The last time we were talking about our 5-part program, we went through section 1, which was deposition is trial. I go back to Mr. Musante that said mediocre adverse depositions abound, while high quality ones are a rarity. So again, what we're trying to do here is to figure out some of the basics of depositions, and I'm going to move on to part 2, which is a deposition has to have a specific purpose. Some people go into depositions, they basically just start asking questions, just general questions. They don't really have a roadmap for themselves. They don't really have a destination. They just want to get in there and start asking questions about the case. And sometimes that works, and a lot of times it doesn't, because if you don't have a specific purpose for your deposition, then you really don't, if you don't have a place to go, you're probably not going to get there. You need to have a place to go. You need to have something in your mind that you're going for. And what I try to keep in mind when I'm doing that is, I try to keep in mind, okay, I pull out the petition that was filed in the case, and I say, okay, what does my client need to prove here? Or what does the other side need to prove? I'm focusing on the elements. So you pull out the petition, you look at the elements, and you say, okay, what needs to be proven, or what do we want to disprove or not allow to be proven? That's your general roadmap. And now you know, okay, I need to get, if you're the petitioner and you want some type of result, you want some type of relief, you want admissions from this witness that will help you get to where you want to go. Of course, you got to know where you want to go. That's why we look at the petition. We look at the various legal issues in the case. Before you take your deposition, this is something I learned the hard way. Read the cases, read the law, know the law backwards and forwards. When that petition comes through the door, or when we first file our petition, there has to be a lot of research that is done in order to know exactly what issues are going to be tried, what are the factual contentions, and what are the factual issues that some witnesses are needed for. That's what you're going for in your depositions. You want to get factual admissions from various witnesses that will help you make your case at trial. When you're in a deposition, what you're going to be doing is thinking, in my closing argument at trial, what am I going to say? I'm going to explain to the judge what the law is. I'm going to explain to the judge what the causes of action are. And then I'm going to fill in all the evidence that came in at trial to make my case. On the other hand, if I'm defending a case, I want to try to show that the other side has not made their case. So you need to do the research before you get to the deposition so you know what you have to prove or disprove. So you got to have a specific destination. You have to have a specific purpose for your deposition. So now you get into the deposition, you know what the petition says, you know what the law is, you know what facts you have to prove or disprove, and at that point, now we're going to head in with this particular witness. You got to think in your mind as you're preparing for this witness's deposition, what does this witness have to say in order to help me in my case? What do I think this witness is going to say? Or what do I want to make sure the witness disproves maybe about something? Or I want to get those testimony nuggets from this witness, and I want to lock those in, because when I get to trial, I want to make sure that when that witness hits the stand at trial, I already know what they're going to say. There's a common saying that most people know, most litigators know or should know: you never ask a question at trial that you don't know the answer to. So when you're cross-examining a witness at trial, you should already know the answer. And the way you know that is to get into your deposition, ask the questions that you want that witness to answer, and then lock them in at your deposition. The second thing you want to do is you want to rule out testimony. Not only are you locking in testimony in a deposition, you are ruling out testimony. So you want to make sure if this particular witness does not know something, that you have locked in that fact that this witness does not know something, because if they get to trial and they start talking and they're saying things that are coming out of their mouth that you've never heard before, there's only 2 reasons for that. 1, you didn't do a good deposition and lock in and rule out testimony. Or number 2, they're just basically adding new testimony that you can try to get excluded, or you can try to impeach them because you basically locked in at their deposition that they did not have testimony about that, and now they're coming up with it at the last minute, and judges do not like that.